Hey guys, so today I'm going to be talking about tenant and landlord relationships, but more specifically evictions. So my dad is a landlord. He does rent out a 3-bedroom, 2-bathroom house in a 1-acre property. So because he did know the people he was renting the house to, it created a tenancy at will, meaning he did do an oral agreement, which under section 92.001 of the Texas Property Code, that is allowed. However, it did backfire as he continued to have problems with the people who he rented the house to. So when he first started that whole process of renting the house to them, she did mention that it was her and 3 other people living in that house. However, we did come to find out that 10 people were starting to live in that house, and she would even hide illegal immigrants there. And it was basically an entire mess. The house was destroyed. Basically my dad had to remodel the entire house with his own money because it was an oral agreement. Nothing was in writing, nothing. He didn't really do a security deposit. So it was basically an entire mess. She was way behind on rent. My dad tried everything in his power for them to move out. However, they were reluctant in moving out, and she basically threatened him. She was like, if you're gonna move me out, then take me to court. I don't care, but we're not moving out. And because my dad was new in the process of being a landlord, he didn't know what to do, and he was scared of basically the entire process of doing so. However, thankfully, after months and months of going through the entire process, he was able to move them out. However, under long circumstances. Because that entire situation was frustrating, I wanted to take a further look into what he should have done in the beginning in order to avoid that situation. And then the first thing that I looked into was, of course, the lease. With the lease in mind, I looked up an example lease agreement in the state of Texas that would be valid, and I found this one. So this lease agreement does have everything that a lease should have. For example, it has agreement to lease, term, basically meaning how long the tenant would be there. And in this case, my dad did rent out the house on a month-to-month basis, meaning that was a periodic tenancy lease. This lease also specifies the rent and how the rent would be paid. For example, cash, personal check, money order, credit card, PayPal, or other. And in terms of that, because my dad did not have a lease or did not specify how he could get paid, under section 92.011 of the Texas Property Code, if the payment is not specified, then the landlord is required to accept cash payments. This lease also specifies utilities, which is what the tenant is responsible to pay. So when it came to my dad, he made sure that the tenant paid for their electric and their water and for their trash. So what my dad did when they couldn't pay the rent and their utilities, what my dad tried to do is he tried turning the power off. However, he was told that he couldn't do that because then he would be responsible for them if something bad were to happen or if they were to get sick. So in this lease, it does specify what the tenant is responsible to pay for. And if my dad would have done this, then he wouldn't be able to take responsibility for that, since it does state in the lease. What I really liked about this agreement is the remedy. And in the remedy, it highlights that if the agreement were to be terminated due to the tenant's fault, the landlord may, in addition to any rights and remedies available under the agreement and applicable law, use any dispossession, eviction, or other similar legal proceedings available in law or equity, meaning that the landlord has every right to evict the tenant if they were at fault. And if my dad would have used a lease and highlighted this remedy, then he would have had every right to evict that tenant and use any legal proceeding available to do so without the fear of the tenants and the court. Even with the lease in mind, sometimes things don't work out the way that you want to. And with that in mind, we have to take into consideration of what the next step were to be if the lease were to be ignored. Before getting the courts involved, the landlord does have the option of using his landlord lien in order to get back the rent that the delinquent tenant has not given. So, a landlord tenant is when a landlord may take some of your property. However, he can only do this under certain conditions. Texas law does not directly authorize that the landlord may enter your home and take your property. However, if in the lease there is a clause permitting your landlord to enforce a lien on your non-exempt property, and if that clause is underlined or in conspicuous bold print, then the landlord is allowed to enforce the lien. However, if, like my dad, there is no lease, then that's when you may want to get the courts involved. Having the courts involved is the last thing that a tenant or a landlord wants to deal with. However, sometimes it is absolutely necessary in order to get the tenant out. So, with this in mind, I made a step-by-step process of evicting the tenant. So basically, step 1 is notice of the vacant. So the Texas Property Code 24.005 requires that the landlord deliver a written notice. My dad did give the tenant a written notice and gave them about a month for them to move out. However, they still ignored it. And if this happens to you, then that's when you can file an eviction suit. So, of course, filing the eviction suit isn't going to be free or cheap. So, in order to file the original petition with the court, you must pay $121, and it is subject to change. The eviction hearing cannot take place for at least 10 days after the petition is filed. Step 3, of course, is judgment. Once the judge has issued, no further action can take place for 5 days to give the parties the opportunity to appeal. Step 4, the appeal. If the tenant files an appeal, the hearing cannot take place for at least 8 days. And lastly, the writ of possession. Once there is a final judgment, the landlord can ask the judge for a writ possession. The writ possession will cost an addition $130. So, of course, doing this entire thing isn't cheap. So the constable must post a 24-hour notice before executing the writ and removing the tenant's property from the rental. So it is not easy, nor is it a fast process. Like you see in the steps, it does take a few days before things can start moving. So as you can tell from the video, it's not an easy process to be a landlord or to even be a tenant. You have to deal with contracts and making sure everything is highlighted, or else you'll be put in a position where you have to take it to court and waste money on removing that person from your property. So, word of advice, and Dad, if you're watching this, word of advice, please write a lease. Highlight everything, not everything on the lease, but highlight your eviction process, highlight the things most important so you don't get screwed over, basically. Thank you for watching this video. I hope you learned something, and I hope you guys have a good break.